Just speak up if you need it.
I need it.
Yeah, I need
Lucy needs it.
Okay, one at a time. Okay, I can see Bree.
How about
Bree
we
and
type
Bianca,
it?
you're now actually recording. Okay.
Oh, I can record.
Well, as long as who else
I can
needs to
record.
record? Just call out your name because I'm on the screen. I can't see you. Who else?
Me, Shari.
Okay. You should be able to record. In any case, some of you are obviously now recording. I can see Bianca, Bree, Heidi's recording, Lucy's recording. Lauren? Can you record? Yeah. Okay. Just play around with the recording. Okay. Make sure you're recording too. Okay. All right. So.
Oh, yeah.
Okay. So that's interesting. Okay. All right. Now what I'm going to do is, it's really important to make this work. Bree, what's your question? Do you have a question?
Yeah, I sent a message.
You were just testing using a message?
Yeah.
Okay. All right. I got the message. Yep. All right. Now, yeah, there we go. All right. So what we're going to do now is I am going to call the roll. And as I call the roll, I want each person to say yes. They're going to have to unmute to say yes. I'll call the roll, and that means I know everyone's here, and we'll be doing that at the beginning of each lesson. Okay? All good. I want everyone muted until the time comes. All right? While you're doing this, make sure you've all got the PowerPoint that I sent through. All right. Everyone should have their mute button on because I can hear feedback. Roger and Maddie don't have their mute button on. Roger and Maddie, put it on, yep. Alison, you haven't got your mute button on.
Oh, you're just mute.
Roger, put your mute button on, and I can't see you. Put your camera on. Alison, same thing. All right, are we ready? Alison, can you get your photo up, please? Roger? Good. Okay. Now I'm going to go through the roll, and as your name comes up, unmute yourself and say yes. We'll start now. Bianca.
Here.
Roger, mute yourself. Listen very carefully to the instructions. The system doesn't work too well if everyone's talking at once. You get feedback and all sorts of things. So, as I say your name, unmute yourself and say yes, and then mute yourself again, okay? But not before. Roger, can you nod? You understand? Roger, can you nod? Yeah, good. Okay, excellent. All right. So, Bianca.
Yeah.
Amelia.
Yeah.
Heidi.
Yeah.
Rianne.
Here.
Allegra. Not here. Brianna.
Here.
Lucy.
Here.
Lauren.
Yeah.
Grace.
Here.
Shari.
Here.
Angelina.
Here.
Roger.
Here.
Roger.
Yeah.
Ella. Megan. No, Ella's not here. Yeah.
Here.
Megan.
Here.
Maddie.
Yeah.
Ellie. Ellie? No. And Alison.
Yeah.
Okay. Good. All right. So we've done the roll. So we're going to start the lesson now. So I want everyone to go to the PowerPoint that I've posted. And the lesson is going to be going through this main idea of, you know, the whole idea of child custody. I think we'll focus on that and focus on the idea of alienation. I've collected some resources, and then after this, we want to be in a position where we can start to write about it, okay? So what I'll do is I'll talk through the PowerPoint with you. If I was on a bigger video, then I'd be able to put the PowerPoint up as a screen and point to it and go through it. And you'd be able to see that as the screen. But for today, then we'll just do this. Is there anyone who's having trouble with the PowerPoint? Has everyone got it open, ready? Is anyone with any problems? Just send through a message on the chat. Bree, you can go to the bathroom if you need to. Okay. All right, let's begin. I'll bring up the PowerPoint on my screen and we'll start with the first slide. Okay. So I suppose what's really important is if you would like to ask a question, you can unmute yourself and ask a question, or you can send through a chat, which will appear as well. Okay. But otherwise, you're just listening and we're talking. Having a class discussion is going to be a bit of a challenge, but it's probably possible. We just have to remember to stop and make sure other people are uninterrupted when they're talking. The conversation is just going to be a little bit different. But I'll just start going through and just see how you go following. So I'm on the first slide now, which is child custody overview. Okay, I'm going to move to the second slide. In the second slide, what I've done is, and this is what we started to do as a class last period, but it was going a bit slowly, so I'm just sort of moving through it more quickly. I've collected the different aspects of international law that we may refer to, depending on what we're writing about, that we may refer to in our extended response writing. So obviously the United Nations Convention on the Rights of the Child we've talked about before. I picked out Article 7 because you can see here, particularly the words right to know their parents. That'll be interesting if we look at adoption, as far as possible, and to be cared by them, okay? So that's really saying, you know, parents should be with their children. Article 9 says children should not be separated from parents, and very importantly here, children whose parents have separated have the right to stay in contact with both parents, unless this might harm the child, okay? So this brings up the idea of what you see in Australian law, meaningful relationship and protection from harm, which we talked about those concepts before. And these are the guiding principles in our law, and they're also in international law. And as you can see, Australia ratified this in 1990. We had law previous to this which pretty much said the same thing in the Family Law Act, but when we signed this international convention in 1990, we were saying, and now international law helps to identify these truths in our legal system, if that makes sense. Ratifying it just means Australia agrees to be a part of it. Okay? And if we had to change any laws, we would do so, but we didn't really need to. Article 18, both parents share responsibility. Now, this is important. We've talked about shared responsibility. Custody and responsibility are two different things, if you remember. Custody refers to the idea of where the child lives, and you know, that can be highly contested. But parental responsibility is about decision making or providing adequate resources, those sort of ideas. And when a court makes a decision, it can take away the idea of parental responsibility, but presumes that unless there's any harm to the child, parental responsibility is continued. Custody, though, obviously, depending on the dispute, depending on the arrangement, orders can be made or agreements can be made, but you know, custody is obviously just a question of dividing the time between the parents. Article 18, shared responsibilities. Governments should help and support them. And then there's Article 19, which talks about violence, abuse and neglect. As I said, we will talk about violence, abuse and neglect, but we will concentrate that to a domestic violence situation. Here, we're just going to be talking about the idea of custody, how custody is arranged and the problems that arise or the difficulties in creating fairness about custody. Is that making sense so far to everyone? Just nod your head if you're good with that. International law. Okay. Good. All right, let's move on to the next slide, slide 3. What I might actually do with my slides is make sure I number them as well, so it's a bit easier. Okay, so there's our international law. We're going to have to quote from that. Here's our Family Law Act, 1975. And in relation to parental responsibility in custody, the main amendment or reform that we want to talk about is Shared Parental Responsibility Act 2006. If we get a question on law reform, this is really important. If you get a question which asks you about law reform, you can go back to the 1975 Family Law Act, where you had no fault divorce and you had a family court. And that's reform. It's like 50 years ago, but it's still reform. It doesn't have to be recent reform. You can talk about the child as something that relates to reform. You can talk about the 2006 amendment as being reform, okay? Reform has happened continuously, but it's any new law, basically. It doesn't matter when it was written, or it's any new judgment. Remember, you can use law reform as common law reform. There's statute law reform, international law reform, which is a type of statute, and there's also common law reform. And those cases that you've looked at are going to be very useful in terms of talking about common law. Ralton and Ralton, for instance, those students who did the Ralton and Ralton case, that case is actually a really important precedent and is quoted widely, okay, for what is established. So when you go back to this, what does the Family Law Act say? It says the Family Law Act came into force 2006. It dramatically changes Australia's child custody law, so it was a big change. Brianna has just returned from the bathroom, so she'll be with us again soon. And then you have, you know, in that slide, you can see the idea of equal shared responsibility. So before this 2006 amendment, there was a tendency for the mother to have most responsibility, for the mother to really be presumed to be the primary carer. This is saying, no, we want equal sharing of responsibility and equal meaningful relationship. That's really important too, okay? So that law establishes equal meaningful relationship with the proviso that the parents need to not harm their child, okay? There was just a chat that happened there. Who was that? What slide are we on? We are on slide 3. It starts with Family Law Act 1975 at the top, okay? That was from Bree, who's just returned, okay? So that should all be familiar. We've looked at that before, and you can quote from that, you know? And I haven't put in quotations from the Act. That's more of a review of the Act, but you can quote, you know, find a good quote from the Act if you want to as well. Okay. Now, this slide, I'm now on slide 4. Slide 4 is going through some observations. This comes from the Australian Law Reform Commission report. So the ALRC you would probably use as a source if you were quoting from this. I should probably have written that at the top. And it says, the making of a parent order triggers the application of presumption that is in the best interest of the child for each of the child's parents to have equal shared parental responsibility. So that means if you go, remember you can't go directly to a court. You have to first go to a family dispute resolution centre and try and have mediation. And if that fails, you get issued with a certificate which allows you to take your matter to court. But when you arrive in court, the court presumes, just like in a criminal court, the court presumes that you're innocent until you're proven guilty. The court presumes that the best thing for a child is to have a meaningful relationship with both parents. Unless we hear otherwise, unless there's real evidence to show that that's not true, we can just presume that's true and operate on that basis, okay? So it says here, must apply unless there are reasonable grounds, means there's good reasons to believe that a parent or a person who lives with a parent has engaged in abuse of the child or family violence, okay? So there's a presumption of equal shared parental responsibility. The sections of the Act are there, you can see, but that's the starting point. And you could say that's a fairly fair starting point. You know, both parents come in, unless you present some evidence, we're going to presume the child needs to be with both parents and it needs to be shared equally. And it's in the best interest of the child to do it. Okay? So, and you can see also from that report, it's saying if reasonably practical. So if it's practical, the child should spend equal time with each parent, unless it's not in the interest of the child or it's not practical. The court will try and give equal time as well, okay, as equal responsibility. And that was never the case before that. In 2006, it was really just, it was quite unequal, and the court didn't think about it being, you know, the court wasn't so concerned with making it equal. The court was really thinking more about just what's practical and what's in the best interest of the child. But here, it was a real call to say, let's make it equal. And then you can see that last thing, which is a good quote to use maybe, that the best interests remain the overriding consideration. So even though we try and have equality, we try and be practical, at the same time, the most important thing that outdoes anything else in this whole process is what's best for the child. Okay, and the court considers that in custody. Right. All right, I'm on to the next slide now. This came from a mother's site, you know, divorced mother's site. And it says, actually, which is interesting, mothers' rights do not technically exist within Australian family law. There's nothing saying in the Family Law Act that mothers have particular rights or fathers have particular rights because they're a mother, because they're a father. Okay? The focus is not on the rights of parents. There's really no rights of parents in there. It's the rights of children under that international convention we looked at that are given the highest priority. Okay, and that's really important as a starting point as well, to understand the law is really about getting things right for kids, not parents. But neither parent should be treated preferentially. They should both be treated equally. It doesn't matter about their gender. Okay? The court bases its decisions on the consideration of the child's best interests. But of course, the presumption is a child's best interests are to have equal shared parental responsibility, equal time. Is that all figuring together? Just nod if you're sort of following it all. Okay, good. All right, let's move on to the next slide. The best interests of the child. I'll just let you read through that, and then we'll see if there are any questions. And if you have a question, you can unmute yourself, or you can just say, I've got a question on the chat. So this is the one that's titled The Best Interests of the Child. Again, this should be fairly straightforward for you. I'll give you a few seconds. Okay. Are there any questions about that? Does anyone want to ask anything? Has everyone had enough time? I'm assuming that made sense and it was straightforward enough. It's interesting that just the language of it is probably good to use, some of the language here and the way it's being expressed. Number one, there are these two ideas about best interest of the child. Number one, the right to benefit, right, to have a good, healthy relationship with both parents. Number two, the right to be protected. And of course, the right to be protected is considered to be the most important of the two. Will override the other one. Safety first. If it means that a child doesn't see either parents because that's the safest thing, that's what will happen. They won't get the benefit of a meaningful relationship. Okay. All right. Now let's move on to the next slide. This is a review of an inquiry into the family law system by Mishka Hudson. Okay. So she's a leading writer about family law issues. What you probably need to know is in about 2017, the federal government was understanding that there were problems in the family law system. It had been going for quite some time and serious problems had been building up, and they wanted a complete overall review of the system. So they launched a Australian Law Reform Commission review, an inquiry, and you'll obviously want to refer to that. A lot of it was about family violence. There were other things in it, but a lot of it was about family violence. So we'll look at that in depth later on. But you will want to refer to that report. This is actually someone discussing what was in that report in 2019. So it comes out in 2018, 2019. And this person here is just making some, she's making some opinions. And that's what we really need about it. Because now we understand how the system works, we really need to see, okay, well, what opinions exist about this? Okay, so if you read it through, the first dot point says that 70% of parents have a separation which is amicable, meaning it works well. But the family law system is most concerned with complex family violence, antisocial behaviours, and mental health issues. So it's saying that those things arise a lot when it's not amicable, when it's not friendly. Okay? Or we might not use the word friendly, we'll just say polite, So, I won't even use the word polite, I'll just say, it was practically done with a minimum of conflict. The gaps in the family law system surround the adversarial nature. So this is now pointing out, and this is a good quote to have. She's laid out what are the main problems with the family law system. And they're going to relate to custody issues, because custody obviously comes up. The adversarial nature. So adversarial nature, if you remember, means the fact that it's one person versus another person, two parties fighting it out. The idea that the whole way the court system exists is to have two sides arguing their case and one winner, where that is a problem with families. There's enough fighting anyway, probably. You need to get agreeing. You don't need fighting, you need agreeing. But we've got this nature in our justice system. And this would be really good to talk about in terms of opinion. The nature of our justice system in family law pits one side against the other with a winner. And it makes people fight it out. Okay? Jurisdictional issues. That means there's problems with overlapping courts. The problem here is you have the family court looking at parenting orders. Then you may have a state court looking at perhaps things like domestic violence orders. And they don't work together very well, okay? It's inappropriate. The cost involved, we'll look at that. There's huge costs involved, especially if you have to get an independent report, which is known as a family report, which requires a forensic psychologist and all sorts of things. They can be tremendously expensive. So problems here, I suppose, in terms of people being able to access the system and resources and so on. Did someone want to say something? No? And then it's very complex. So that quote there is talking about the main issues in it. Complex. All right. What was that? Chat. Could we slow down a little? Lauren May. Okay. So Lauren, where are you? Lauren, can you unmute yourself?
Yeah.
Yeah, that's good you said that, because you're probably not the only one. What bits would you like to slow down or go over a bit more?
I've caught up now, but it was the part to do with best interest of the child.
You were still on best interest of the child?
I've caught up now, but that was from before.
That's from before. I think, you know, like as a general rule, we need to have everyone on the same slide at the same time. But remember, are you recording this? Yeah, so you've got it to replay if you need to, which is a real benefit. Okay, this might be good for study, you know, later on. Okay, you want to mute yourself again, unless there's any other questions? Good. Okay. Now, what I wanted to focus on, and if you look at the cases that you've looked at already, you'll be able to use those cases. People in the waiting room. Shari and Angelina, what's going on there? Okay. Those cases that we saw and we looked at, they were difficult cases in the sense that there were some really nasty things happening in those families. And a lot of them included child abuse allegations. This is really good. It's really good to quote the Australian Institute of Criminology and back things up with statistics when you talk about family law. And it's saying, although we have problems in the family court because people make allegations of child abuse, false allegations are only found in 9% of cases. Which is false allegations in family law, they're going to make false allegations in criminal law, okay, at about the same rate. So about 1 in 10 times an abuse allegation is made, it's found to be false. I think that's really interesting, and you can quote that statistic, okay? And then this person's opinion is that despite the fact that there's a very low case of people actually making allegations against their partner which are untrue, judges make ex parte orders, meaning they go out of the courtroom, they meet with the lawyers in the back room, and they just make a decision that this allegation is false. And that shouldn't be happening. They just say the sexual abuse is not likely to occur. This has been because the mother's been anxious, has been saying things to the children. We saw that in some of the cases we looked at. I'm going to give the child to the father. The mother's causing trouble. She's making allegations that aren't true. And what this person is worried about is, do judges really understand that most of these allegations are true, or are they making judgments where they just don't believe the mother? Do you know? So they're questioning whether or not allegations are properly dealt with. And the problem is that women who make allegations in terms of resolving custody sometimes lose access, as we've seen, because they've been difficult, because they've made allegations, or because they have alienated the child. They will risk the fact that they may lose the child and may go to the father, which is a much worse outcome. Okay, because then the father would be able, if the mother believes that, you know, the child is placed in an even more dangerous situation of abuse or harm. And the opinion here is many highly capable protective parents have lost their children to the perpetrators of abuse to their children. You know, that's a huge weakness to the system, isn't it? Massive injustice occurring here if we talk about fairness. So this is where, you know, we talk about balance. And I was talking about this to Amelia the other day. Every time we look at an issue, we want balance, don't we? We want to be balancing two sides. So perhaps on one side, we balance the fact that there are fathers or mothers who are being unfairly accused of abuse or mistreatment of children, that are losing access to children because of alienation. On the other hand, you have the danger that, you know, children are being placed because people are not being believed and the system is trying to balance things too much. Children are being placed in the care of perpetrators of abuse. And how do we ensure that that's happening? And when you look at the cases we've looked at, that's where you'll see the detail on that. Okay. All right, well, I'll just finish this slide. Okay, and the last thing is a really nice quote. The Australian Law Reform Committee has overlooked a flaw in the system about it being a specialised court, and the approach has failed. It's a dangerous institution. It doesn't identify risk or proper safeguards. Okay, that's a very damning comment about the family law system, based on the fact that children are being put in dangerous situations. Okay, now my phone is about to run out of battery. So what I'm going to do is let's end the class there, come back to the room. We'll continue it sort of in the classroom, but you can see how it works. All right, we'll come back and discuss it. All right, everyone back to the room.